Straight ahead on Law and Crime Daily.
American women today have less freedom than their mothers.
Abortion violence is the #1 killer of children in America until today.
The Supreme Court overturns Roe v. Wade. And Johnny Depp and Amber Heard's teams are back in court. Does Amber Heard plan to appeal? Plus,
I've been informed that you've reached a verdict. Is that correct?
a verdict is handed down in the Candy the Dog civil trial. And later, from alleged child grooming to unsafe living conditions, we take a closer look at allegations against actor Ezra Miller. Law and Crime Daily, covering court cases from coast to coast. Welcome, everybody, to Law and Crime Daily. I'm Jesse Weber, in for Brian Buckmeyer. A monumental ruling by the Supreme Court of the United States as Roe versus Wade is overturned on Friday. Back in 1973, Roe v. Wade was a landmark SCOTUS decision, ruling it was a woman's choice whether to have an abortion. But on Friday, Supreme Court justices overturned that ruling, meaning women no longer have a federal constitutional right to abortion. From here, abortion rights will be decided by each individual state unless Congress intervenes. Right now, nearly half of the states have abortion bans. The ruling came from a split decision with justices nominated by Republican presidents holding the SCOTUS majority. Justice Samuel Alito wrote in part, quote, "Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision had damaging consequences." In a joint dissenting opinion, Justices Stephen Breyer, Sotomayor, and Elena Kagan wrote in part, quote, "With sorrow for this court, but more for the many millions of American women who have today lost a fundamental constitutional protection, we dissent." Now, all of this comes weeks after Politico released a draft opinion showing the court voted to overturn the ruling. House Speaker Nancy Pelosi said Republicans are on a crusade to criminalize health freedom for women.
What this means to women is such an insult. It's a slap in the face to women about using their own judgment to make their own decisions about their reproductive freedom. This is deadly serious, but we are not going to let this pass. A woman's right to choose reproductive freedom is on the ballot in November. We cannot allow them to take charge so that they can institute their goal, which is to criminalize reproductive freedom.
We also heard from Republican leaders who praised the SCOTUS ruling.
Speaker Pelosi just lectured us. She said guns are the #1 killer of children in America. That's not true. Abortion violence is the #1 killer of children in America until today. There's no right to abortion in the Constitution, and thankfully the Supreme Court finally said that decisively. Thanks be to God.
Joining us today is co-host Terri Austin and former prosecutor Bernarda Villalone. It's great to see you both. Bernarda, I'll start with you. After nearly a half a century, Roe v. Wade has been overturned. What is your reaction to a really monumental ruling?
Jesse, today the Supreme Court issued a devastating blow to us women. Us women, our reproductive rights. It's funny because I'm looking at the Supreme Court, and etched in the Supreme Court is equal justice under the law. And that is exactly the opposite that the U.S. Supreme Court issued today when they determined that a right that I was born into no longer exists, that it shouldn't have existed from the very beginning, and that being the right to choose on whether a person wants to have an abortion.
Well, Terri, everybody's wondering what's going to happen next. So it's up to the states to decide, but what could those decisions look like? I mean, do you expect to see women flooding to states where abortion is legal?
Every state is going to make their own laws, and it will be in accordance with that legislative agenda. Some of the conservative states are going to ban or severely limit access to abortion. Liberal states will probably grant women access in accordance with Roe v. Wade, which is saying that abortions are going to be restricted only after the viability, which is the first trimester. And so I do think we will see women traveling from state to state. This is going to make it very difficult for women who don't have the economic means to do that. And so it's not fair for those women who won't be able to make their own decisions and have that choice. So we're going to see a lot of different events in different states based on how that state makes their laws.
Right, and a separate issue about whether or not Congress will actually codify law regarding abortion rights as well. Still ahead on Law and Crime Daily, a verdict is reached in the Candy the Dog trial out of Florida. But first, Johnny Depp versus Amber Heard, the latest from the Fairfax County Courthouse. Welcome back, everybody. Nearly 1 month after the verdict, Johnny Depp and Amber Heard's teams are back in court. Law and Crime's Anjanette Levy joins us now from the Fairfax County Courthouse with a breakdown of Friday's hearing.
This hearing was largely a formality, and Judge Penny Azcarate, who oversaw this case, was no nonsense as usual. Cameras were not allowed inside the courtroom for the hearing, but the hearing was open to the public. Amber Heard's attorney, Elaine Bredehoff, told Judge Azcarate that she wanted to file motions and have a hearing. But the judge told her, "I've had this case for 18 months and we had a 6-week trial. I'm not having a hearing." Bredehoff also wanted to address the fact that Amber Heard has to post a suspension bond, which is the judgment awarded to Depp of $10.35 million, plus 6% interest annually, in order to appeal. Judge Azcarate told her that is the procedure. Meanwhile, Johnny Depp's team posted an exhibit with the judgment outlining why they object to the judgment against Depp for statements made by his lawyer Adam Waldman to the Daily Mail. There are several bullet points in the exhibit, including the fact that Depp feels the $2 million award was excessive and that finding Depp liable was contrary to the facts and the law. Meanwhile, there were some supporters for Johnny Depp in court for the hearing.
My thoughts on today's hearing were kind of the way I felt during the whole trial itself, is that I feel like Amber Heard's attorney, Elaine Bredehoff, was still trying to get things and argue a little bit with the judge wherever she could. I think Judge Penny was just done and she wasn't having it. Today, filing the judgment was basically all they were here to do. And so I think that, it was pretty simple and easy and straightforward, other than Ms. Bredehoff trying to get few things here and there.
I approached Elaine Bredehoff, the lead attorney for Amber Heard, and asked her whether she would speak with us on camera and if she had anything to say. She said no. But Amber Heard's spokesperson issued a statement saying, as stated in Thursday's congressional hearings, you don't ask for a pardon if you are innocent, and you don't decline to appeal if you know that you are right. Amber Heard has 30 days to post that suspension bond and file an appeal. For Law and Crime Daily, I'm Anjanette Levy.
All right, so Terry, a lot of people thought that with the verdict it was done. So is it normal to have a hearing like this after a verdict is handed down?
What's normal, Jesse, is to have a hearing where you are actually hearing the judgment. So you get the verdict, and it does take time to draft that judgment. Usually the prevailing party drafts the judgment. And so Judge Azcarate said to bench you, draft the judgment, show it to opposing counsel, make sure you agree on the wording, come back on June 4th, and I will enter that judgment. Now, in the meantime, of course, they could have had discussions about settlement if they wanted to. Turns out there will be no settlement. And in fact, just the opposite. We know for a fact that Amber Heard is going to appeal. Just 30 days to file that notice of appeal. And then, it'll be out of Azcarate's hands and it'll go to another court. But yeah, so it's normal to have a hearing, but just to enter the judgment, most other things aren't done. And I think that's why the judge was impatient.
All right, well, let's talk about that appeal. So what does this all mean, Bernard, in terms of a potential appeal for Amber Heard and whether or not she'll have a successful appeal?
Well, the question will be is whether she has the money to pay these attorneys for an appeal or for a new trial if the appeal were to be granted. All of this takes time, it takes patience, and it takes a lot of money. I can tell you, just ordering the transcripts on a daily basis, you're talking about pages that cost about $3 per page. And we know that there were hundreds of hours of testimony. Now, will an appeal be granted in this case? I highly doubt it. But hey, today, so many surprises, you just never know.
That's a good point. You just never know. And I think at a site, it's so expensive filing these lawsuits, which might be one of the reasons why Johnny Depp decided, hey, I'm not going to forego or waive my right to the monetary judgment. He's got lawyers to pay. So it's something to think about there. All right, coming up on Law and Crime Daily, actor Ezra Miller faces multiple accusations, including that he groomed a teenager. Plus, a verdict is handed down in the Candy the Dog civil trial. Welcome back. Closing arguments are presented and a verdict is handed down in the so-called Candy the Dog civil trial out in Florida. Rodney Jacobson is seeking justice for Candy after his beloved Terrier Pit Bull mix was shot and killed by Zach Dieterle. The lawsuit stems from an incident in 2016 at Dieterle's family property where Jacobson stored his boat. Now, Dieterle says as he walked towards Jacobson, Candy snarled and snapped at him in what he says was an attack stance. He testified he tried to stop Candy by kicking rocks at her and kicking the dog, but says he feared for his life when he pulled out his gun and shot her. Jacobson says Candy had no history of aggression. Dieterle wasn't charged because local officials say he was within his rights to use deadly force and he had a permit to carry the weapon. Now, before the case made it to the jury, attorneys on both sides made one final plea Thursday. Jacobson's attorney used Dieterle's own words to argue for his client.
Still in utter disbelief at what had just transpired, turns to Mr. Dieterle and says, "Did you just shoot my dog?" Defendant's own admission on the stand. "You're damn right I did." He tried to tell you about how remorseful he was. Yet immediately after the incident, he called Mr. Jacobson an effing moron. I'm going to pull back the language. We've already heard it enough in this courtroom. Effing moron. GD idiot. Brandishing the firearm at him. Does that sound like somebody who's truly remorseful? You're damn right I did. That's not something you say to someone right after you shoot their dog, even if you are in fear for your life.
From there, Dieterle's attorney presented his side's closing argument, arguing his client believed he was going to be hurt by Candy and in turn says he had no other option but to shoot the dog.
Even despite the efforts of Mr. Dieterle to try to kick the dog away from it, after it made several passes at him, after he couldn't back up anymore because he risked falling into a mud pit, after he yelled to Mr. Jacobson, after he had already tried all those other things to keep the dog away from him, while Mr. Jacobson stood silent doing nothing, that Mr. Dieterle had to take out his gun and shoot the dog. Otherwise, he risked injury. Mr. Timpanic liked to point out the fact that Mr. Dieterle was not bitten, he had no bite marks, his clothes weren't torn up with the dog's teeth. Thankfully, that is true. But had Mr. Dieterle fallen in the mud pit that was directly behind him, it could be a totally different story.
The jury handed down the verdict Friday afternoon after just 2 hours of deliberating.
I've been informed that you've reached a verdict. Is that correct?
Yes, Rodney M. Jacobson, plaintiff, versus Zachary K. Dieterle, and Spring Release LLC, a Florida limited liability company. Defendant. Verdict. Preliminary question. Was Mr. Dieterle justified in using deadly force against the dog in self-defense? Yes.
Okay, so Bernardo, let's start with those closing arguments we just watched. Two very different styles, two completely different narratives. What did you make of it?
Two different styles, of course, and two different narratives. If they were the same narrative, it wouldn't be a trial. But what I can tell you from the snippets that we saw is that both sides used the best facts that they had in order to create a story for the jury. And I think when it all came down to is that you can't get past the fact that, yes, this is a dog, yes, this is an animal, but it's a dog that is capable of causing injury, immediate injury. Have you ever been chased down the street by a dog? You are scared. So you just never know what could happen. So that's why I'm not surprised at the verdict from this jury.
Terri, what about you? I mean, this was a lot for the jury to consider. Do you think the jury, based on everything you've seen in this case and all of the evidence and both the plaintiff and the defendant taking the stand, is this the correct verdict?
You know what, Jesse? I watched this case very closely. Yes, it is the correct verdict. It's a tough situation. Obviously, no one wants to hear about a dog being shot, but the jury focused on two factual issues. Was Candy aggressive? And whether or not Dee was afraid for his life. As to the first issue, several witnesses testified that yes, Candy was aggressive. They saw her snarling at other people, and they, in fact, were in fear as well. And then Dieterle got on the stand. He was an excellent witness. He testified that he was in fear of his life. He was surprised. He saw Candy coming at him, tried to back up. As you mentioned, he kicked dirt first, so he didn't shoot immediately. Then he actually made contact with the dog when he kicked her, and he hit her head. So he ended up shooting her only as a last resort. And he was able to convince that jury that he only shot because he was afraid for his life. He didn't shoot after the dog after it ran away. He only shot the dog trying to stop it from attacking him. So I think it was the right decision all in all. And I think the jury came down quickly with that decision because the facts were pointing to that direction.
Well, I will tell you, I'm surprised by both you, Terry, and Bernardo, because a lot of our analysts who I spoke to completely disagreed and thought that Rodney Jacobson was going to win. So this seems like it's going to be a verdict that will have a lot of people divided in the time to come. Well, starting next week, Law&Crime is going to be covering a new case out of Ozark County, Missouri, the bench trial of Rebecca Rude, a woman accused of killing and dismembering her daughter, Savannah Leckie, in 2017. Savannah, who had autism, was adopted at birth by Tamil and David Leckie in Minnesota. And after the Leckies separated, Savannah moved to Missouri to live with her biological mother, Rude, on her Theodosia area farm. Now, 11 months later, Rude reported her daughter missing on July 20th, 2017, and it wasn't until later that her remains were discovered burned on Rude's property. The same day law enforcement discovered the remains, Rude married her boyfriend and co-defendant, Robert Peet. Both of them have been charged with first-degree murder, second-degree murder, child abuse resulting in death, tampering with evidence, and abandonment of a corpse. Opening statements are slated to begin Monday morning, and you can follow Law&Crime for gavel-to-gavel coverage. When we come back, actor Ezra Miller under fire. We take a closer look at the reports that are underway. Welcome back, everybody. Actor Ezra Miller is making headlines for a slew of bizarre reports involving unsafe living conditions, grooming teenagers, and a one-year-old child who put a bullet in their mouth. Miller first made headlines several weeks ago for back-to-back arrests in Hawaii for causing a disturbance at a karaoke bar and later for throwing a chair. This week, Rolling Stone released a report saying Miller was housing a young mother and 3 children in unsafe conditions at a secluded Vermont farm. The report states that guns are lying around the home, including in the living room, where a 1-year-old child put a bullet in her mouth. Rolling Stone also says that there's heavy marijuana use at the home in front of the children, ranging in age from 1 year old to 5. And at the same time, officials in North Dakota sent out a protective order against Miller, who is yet to be located by the court. Parents there accuse Miller of grooming their teenage daughter with cult-like behavior and violence. All right, Bernardo, I'm not even sure where to even begin here, but what sort of repercussions could Miller be facing here in light of all these accusations?
I'm waiting to hear when the Department of Children and Families are going to go to the location and try to investigate these allegations before it's too late. Of course, we never want to hear that something has happened to a child or that the police are running onto someone's property for no reason at all. But we need to be careful because we have all heard of those kids that have died at young ages at the hands of others who don't properly care for the environment that the children are in.
Bernardo, let me just follow up with you in a second. How come they can't find him?
I don't understand how they can't find him if the media can find him and take pictures of him.
That's a good point. I mean, Terry, look, how do you prove something like unsafe living conditions for a child or even grooming a teenager? These are not accusations that we hear typically and not amount to charges that we've heard typically. We've kind of heard a little bit with Ghislaine Maxwell.
Absolutely. In fact, I was going to mention that. With the unsanitary conditions, there's all kinds of evidence that can be presented. You can show that there are, a situation where the house isn't kept clean, where you're not getting food, where there's physical abuse, even bruises or broken bones, or there's emotional abuse. So any type of evidence where there is a condition that is not safe for that child, it could be a range of things. And as far as grooming is concerned, like you said, Jesse, we saw that in the Ghislaine Maxwell case. That is actually defined as establishing a relationship with that child in order to promote some sort of sexual activity. And it could be grooming with the child, it could be grooming with the family, which it does sound like might be occurring here. And it takes place by lowering that child's inhibitions. You try to make a friend with that child. You try to give them gifts. You do all of these things that the child thinks that you are becoming close to them and that you're a friend and that they will trust you. So that's what they'd have to prove. They'd probably use an expert in the case if this case is actually brought to show that all of those things have been occurring. So we'll see what happens.
We will. I mean, these are disturbing allegations against this man, so we'll see what happens. Bernarda, Terri, thank you so much. Everyone out there, thanks for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.